I would have always said that these are key documents, but they are especially key documents in light of COVID. And we're going to talk about that and talk about why. I'm going to briefly share my screen just so I can show you a visual of what kind of documents we're talking about. And I know that I said we're going to be discussing 3 key documents, but there are going to be a few bonus documents that we discuss as well. So sorry about that. Here we go. So we have here, these are the essential estate planning documents. So you see, starting on the left, I'm going to start with the living will, up to the durable power of attorney, the healthcare proxy, and on the bottom are going to be the bonus documents that we may get to and just touch upon very briefly at the end, last will and testament and living trust. But when I'm talking about the importance of estate planning in terms of COVID, really it's those top 3 on that circle that I want to focus on. And so you can think of this as the full picture, and then we're really going to be focusing on those top 3 documents there. So that being said, what have we learned from coronavirus, from COVID-19? We've learned a lot of things, and I think one of the most important things we've learned is the unexpected turn that things can take and how that can happen quickly. And while we can't always prepare for the exact circumstance, it is most important to have documents in place where we can prepare or expect the unexpected. And that is really what we're talking about with these documents. Even before this time, when I discussed estate planning with clients, I referred to the documents that are most important while they're alive, and then those documents for after death. And when we talk about these 3 key documents today, we're going to be talking about the estate planning documents that are most important while somebody is living. These 3 documents only pertain to a living person. And so we'll go through each one of them. So the healthcare proxy and the living will are the first 2 that we're going to discuss. And they are what we call advance directives. So they are signed in advance of needing them, and they are meant to direct your wishes should you become incapacitated. So the healthcare proxy is a document that states who you would want to make medical decisions on your behalf should you become incapacitated as determined by a doctor. So that can be a temporary incapacity, such as people who are placed on ventilators or who were unable to deal with the doctors when they were in the hospital. And we saw this happening a lot, especially at the beginning of COVID, where there was a lot less communication, quick decisions had to be made, and the doctors needed somebody to have that line of communication with. Or it could be a longer term incapacity, such as something brought on by a cognitive impairment like Alzheimer's or dementia, where you're unable to make your medical decisions. It's important to note that the healthcare proxy is only in effect when you're incapacitated. So if you go to the doctor and you talk to your doctor and then you go home and your family member who you've named as agent on a healthcare proxy calls the doctor and says, I want to know what happened when my loved one went to the doctor today, they're going to say, well, we can't speak with you. You're the healthcare proxy, but that's only in effect if they're incapacitated. And she's not incapacitated. She came into our office today. We talked to her. Everything was fine. And so you'll need a different type of authorization if you need a release of information. So that's a very important thing to note. Also important to note about the healthcare proxy is that it does not require an attorney. It does not require a notary. It only requires that you sign in the presence of 2 witnesses over the age of 18 who do not have an interest in the document. So you can't have as a witness somebody that you're naming to act as your healthcare proxy. And I would say to have totally unrelated people is your best bet. I have my first healthcare proxy that I ever wrote was when I was having my appendix out and I was on my way into surgery, and it was about 1 o'clock in the morning in the emergency room, and a nurse's aide and somebody who was in the janitorial staff came over and were my 2 witnesses, because I knew that if I was temporarily in that case under anesthesia and therefore unable to make decisions, I wanted to be very clear on who would make medical decisions for me. Now, why does that matter? Well, there's a default in place So had I not signed that power of attorney, there's a default in the law as to, if I'm in a facility, who makes my medical decision. But what if I didn't want it to be the default person? Or what if there are multiple people under that default level? So let me give an example. An individual's default, if they're in a medical facility and they're unable to make their own decisions, their surrogate decision maker will first be a spouse. If they don't have a spouse, it would be their children. If they don't have children, it would be their parents. If they don't have parents, then it would be their siblings, et cetera, et cetera. And there's a list. So let's say that I have no spouse, but I have 4 children, and 2 of them believe I should get a certain treatment and 2 of them believe I should not. If we're dealing with the Family Healthcare Decisions Act, which is the default under the law, then we don't have the ability to choose between which one would have the right to pick. And then the doctor's in a spot where they have 4 people that they're technically supposed to be listening to, and they have different opinions. And what does the doctor do? Whereas if I signed a healthcare proxy and I made it clear that there was one specific of those 4 that I trust, that I've discussed my wishes with, that I believe would act as I would act if I was able to speak for myself, and that's the person I would want to make that decision. And so you want to be sure, again, that you are in control even when you do not have the mental capacity to be in control in that moment. And the only way that we can do that is by planning in advance and signing these documents and making it so that the best person that we can think of to follow our wishes is empowered to do so, without the interference of anyone else who might not align directly with what I would want if I were incapacitated. A healthcare proxy also should state that your agent, you should have a conversation with your agent under the healthcare proxy about your wishes regarding end-of-life decisions, artificial nutrition and hydration. And then there should be language in your healthcare proxy document that actually states that your agent knows your wishes regarding these things and is empowered to make those decisions. So you want to be clear that they're not just making routine decisions like, you know, should we have a certain test done or something like that, that it's beyond that. It's, should we have a feeding tube? Should we have artificial hydration? Should we have antibiotics if it's to treat an infection, but the underlying issue is much larger than that? These are the types of things that you want to not only put in the document, but you also want to have those broader conversations with your agent so that, again, they can step in your shoes and do what you would most likely do if you had the information being presented by the doctor. So that's a healthcare proxy. The state has a form. So a lot of people say, how can I get a healthcare proxy? You can actually go online to the New York State Department of Health form and print it out. It is 2 pages, often printed double-sided. You sign on the second page, as do the witnesses. You have to sign in their presence. And on the first page, you say who your agents are. Important is that you're only allowed to name 1 agent at a time. So you can't have 2 co-agents, but you can have a successor agent. You can have a second person in line. When we do estate planning documents with clients, we often use our own form rather than the Department of Health form because we're able to put multiple people. So the Department of Health form only leaves rooms for spot 1 and spot 2. Whereas in my example where somebody has 4 children that they might want to name in order, 1, 2, 3, 4, not necessarily age order, whatever age they want, we can include them all in the document. It's also important when you have multiple agents or multiple children that you really think about who would be the best to act in that circumstance. And so people often ask me, well, who should I name? And the questions that I then ask them back is, if you had an emergency and you had to call someone, who would be the first person you would call? So that's one of my first questions. Another question would be, if you are having a conversation about healthcare, who is most aligned with what you find to be appropriate? Also, for some people, there are religious beliefs that come into this. So who of your options is religiously aligned with you? And then also, who is the most decisive? So some people say, well, you know, my daughter and I get along so well and it's really great, but I don't think she would be able to make a decision in this circumstance. She would waver too much. It would be very hard for her. So you want to look into that. So practically speaking, who do you believe would be the person that would pick up the phone, digest the information being presented to them, and then come up with a solution that's closest to what you would choose for yourself? And that isn't necessarily the oldest, and it isn't necessarily the most popular choice, but it's what is going to serve you best in that circumstance. The next document is the living will. The living will and the healthcare proxy often interplay with each other because the living will is a statement of your wishes. So it says, if I'm in an irreversible state with no reasonable expectation of recovery as determined by a doctor, then I empower my agent to withhold or withdraw certain treatments. So again, you're leaving everything in the hands of the healthcare agent. We want the person you chose to be able to make that decision, but we want to give them some guidance. And we also want to give them some backup. So if there's some pushback from the other family members or other loved ones as to whether or not a certain treatment should be given or withheld, we want the healthcare agent to have that living will to say, no, I know this is what she wanted. She signed this document saying she wouldn't want to be kept alive under certain artificial means indefinitely if there was no reasonable expectation of recovery. And so that living will is a very broad statement because obviously when it's signed, I called it an advance directive. It's signed in advance. We don't know what your ailment will be. We don't know what doctor will be your doctor. We don't know what other things will be going on in your life. We don't know what other items you'll be treated for. Maybe you have multiple diagnoses, and we also don't know what treatments will be available at that time. And so it has to be written somewhat vaguely to empower that agent and give that agent direction without tying their hands where they can't take advantage of maybe what might be a new treatment or a change in circumstances from when you signed that document. Again, in light of COVID, these were really important documents for those who went into the hospital, especially because you didn't have the family members being able to be right at that bedside the way that you would have prior to COVID-19. So it used to be that if somebody was rushed to the hospital, the healthcare agent was called and they would be right there. They would be making those decisions at the bedside in real time. But when we were dealing with a situation where at best the agent was on the phone or via telehealth or on an iPad through FaceTime, whatever the people in the hospitals were able to do, we really saw the importance of these documents and of taking control of what might happen to you should you be in that circumstance. So that's the healthcare proxy and the living will. The living will has the same signing execution requirements as the healthcare proxy. The living will needs 2 witnesses over the age of 18. And again, it should not be somebody that you've named in the healthcare proxy to act as your agent. You want 2 disinterested witnesses. And they are saying that you stated that these were your wishes and you were of sound mind and you were who you said you were and you signed that document. No lawyer required and no notary required. I will point out, and the item of execution is going to change when we get to the 3rd document, the power of attorney. With the first 2, there were 2 important things that are going to change now. One is they don't need an attorney. Although the power of attorney doesn't technically need an attorney, I would strongly recommend, and actually the New York State statutory form recommends, that you seek the advice of an attorney because of the power that you're giving to somebody else over your finances. And also the difference is that it requires a notary to sign. And so the healthcare proxy and the living will are signed by any 2 people over the age of 18 who can say that they witnessed you signing that document. The power of attorney is kind of a step up from that. The power of attorney also does not require incapacity. So with the healthcare proxy and the living will, I referred to those as advance directives because they're being signed in advance of needing them and in advance of them being in effect because they're meant only for your incapacity, temporary or long-term. Whereas a power of attorney is in effect when you sign it. So a power of attorney is a document that gives certain legal authority to the person or persons that you name to access your financial records, access your bank accounts, deal with banking institutions, real estate transactions, enter into contracts, represent you in lawsuits, apply for government benefits, create trusts. These are all possible things that your agent under the power of attorney can do on your behalf. It's very important to note that not every power of attorney is going to give every power to the agent. So some people choose to only give certain powers to the agent. So they may say, well, if I need them to act on my behalf, I want them to have access to my checking account and to do banking transactions to make sure they're paying my bills, but I don't want them to enter into contracts and I don't want them to sell real estate. And that may be the decision. And again, these get to be very nuanced conversations, which is why I highly recommend that the power of attorney be signed with the advice and the oversight of a lawyer, of an attorney, so that you can make sure that you're fully understanding the pros and cons of the powers that you're giving out, and then making a determination as to what powers to give or whether or not to give complete plenary powers with that advice and the knowledge of what you're actually doing. The New York State power of attorney was amended. Very large changes were made in 2009 with very minor changes in 2010. So the form that we're currently working under is the 2010 power of attorney form. It may not be altered in any way. You can't change the powers as written unless you're writing them into the modifications section. And so there's a grant of authority right at the beginning that have powers A through O, and you can initial to give all the powers, or you can pick and choose the powers, but in no way can you delete that from the current document. If you want to not give a power that's in that section, you would simply not initial next to that power. If you want to give powers to your agent that go beyond the A through O, that is when you would utilize the modifications section and add those powers in. That document also has what we call a statutory gifts rider. A statutory gifts rider gets signed at the same time as the power of attorney document, gets attached to it as if it were one document, and it allows your agent to make transfers. So the difference is that while the first portion, the power of attorney document, says that an agent can act on your behalf and pay for goods and services and pay your bills and engage in transactions for you, the statutory gifts rider is talking about uncompensated transfers, such as creating a trust and transferring my assets to a trust, giving my donation to a charity, giving a gift to a grandchild, to a child, to a friend. All of these straight transfers of assets must be done with a statutory gifts rider under the current law. It's very important that when you're giving the power for your agent not only to access your bank accounts, but to also give away assets in your bank accounts, that you again get advice to understand why this might be important for you or why it is not a good idea, and then to make an informed decision as to what's the best option for you. The power of attorney document as it stands today is notarized, and then the gifts rider is notarized and has two witnesses, one of which can be the notary. So you need two other people in the room with you when you sign that document. It also requires that the agent that you're naming to act on your behalf is named as, it actually signs the document in front of a notary. While it is in effect as soon as you sign it, and therefore does not require incapacity to be in effect, you can hold off on having your agent sign and have notarized the document. And if they have not yet signed it or notarized it, then they can't act on your behalf. And some people do that when they are younger or healthier, and they're not worried about someone having to act in the short term on their behalf. It's more of long-term planning. They hold on to the document and they let the agent know that if something should happen to them, where to go to get the original document, to have it signed and notarized by the agent so they can act on your behalf. And again, how to go about having the agent sign, when to have the agent sign, and what to do about where to keep the document is something you should discuss with your attorney to make sure you're doing what makes the most sense in your circumstance. The worst thing that happens is when somebody creates all of these documents, and they go through all the work, and then they become incapacitated or they're in the hospital and nobody knows the documents exist. With a power of attorney, they're going to want the original document with the signatures as originally signed by the principal, the creator, and the agent. When a bank wants to see it, they usually want to see the original and they take a copy. With the healthcare proxy, it's important to note that a copy is as good as an original. So when you make that healthcare proxy, you want to put that on file with your doctors, you want to give a copy to your agent, you want to bring a copy with you if you do have to go into a facility, so it's very clear who to call and who to contact. And we usually put cell phone numbers and home numbers on that document if someone has both. It's very important that your agent be able to be reached. So the power of attorney, I keep talking about right now, right now, right now. Why? Because in December, just this past December of 2020, the governor signed a bill that was passed through both houses of the New York State Legislature that amended the General Obligations Law and amended the New York State statutory power of attorney. This is an effort that has been pushed forth by the New York State Bar Association, Elder Law Section, Trust and Estates Section. There was a task force put together by the Bar Association to push this forth, to change that 2010 form and document to try and make it more user-friendly and easier and have less mistakes. And that is the goal of this new law. The new law goes into effect in June of 2021. So right now, if you go see a lawyer, you'll still be signing under the old 2010 form or 2010 law. If you sign after June 13th, you're going to want to sign under the new law. But that doesn't mean that your old document isn't valid anymore. So if you sign one now, or if you signed one 6 months ago or a year ago or 2 years ago, and it was valid when you signed it, it will still be valid after that June date, after the new law goes into place. It just might be that down the line, as the old form becomes more and more outdated, you may want to update your documents to just be the most recognizable by the banks and other institutions that you're presenting the form. But again, it will not be invalid just because it was signed prior to that date, as long as it was valid at the time under the laws it was signed. The new power of attorney does a few things. It removes that second portion. It removes that statutory gifts rider, and it puts it actually up into the modification section of the power of attorney document. So the power of attorney document still requires a notary, but we anticipate an amendment is going to pass through that's also going to require witnesses. Again, one of the witnesses can be the notary. One of the really great things that this new law is going to do for the physical disability community is it allows for an individual to sign the power of attorney on behalf of someone who can't physically sign for themselves. So the person who is conferring the power, so if I'm giving the power to an agent to act on my behalf, I will still need to be present in the room with the witnesses and the notary. I will still need to have the person who's signing on my behalf be in the room, and I'll still need to express my wishes to sign this document and that I have the cognitive ability to sign this document. But then I can have another sign on my behalf. And that is going to be a huge deal for those who are unable to physically sign the document, but want to give these powers to another to act on their behalf. And so we're really excited about that part of the law. The other thing that we're hoping that this new law does is it's going to put into place a procedure for when a bank or other institution does not want to honor a power of attorney. So those of you who've ever been agent under a power of attorney who've maybe brought that document to the bank may have hit some resistance when trying to put it on file. And this has been a complaint that we've heard about for many years from clients, and we're trying to make it so that this happens less. And so the bank has a certain number of days to reply to a request to have a power of attorney on file. There's an opportunity for the attorney who signed the document with the individual to give an opinion letter. And the bank's rejection or the institution's rejection of that document must be on a reasonable basis. And if a court hearing is brought on this and it's found to not be reasonable, then the institution can be charged attorney's fees as part of damages and costs to recoup the money lost on fighting this if it was not reasonable to reject it in the first place. And so hopefully that is going to make things a little more user-friendly for those that are caring for somebody who is incapacitated. There are other changes in this power of attorney law that, such as if you didn't have the statutory gifts rider before, you could only give gifts of $500 or less. Now that number is being raised to $5,000. And if you want there to be transfers above $5,000, then again, that needs to be put into this modification section under the new document. And they are going to also be making it so that if you have a word that's off or a slight change in the statutory form, it won't be the death knell for the document. The document can still stand as long as it's clear that the intention was to give these notes. So those are, again, the three key documents that we want to focus on to make sure that everybody has them in place. And what we've learned in COVID, again, is to plan for what we can't plan for and to have control over the things that we won't have control over. And the way that we do that is by empowering certain individuals to act on our behalf. And even more importantly, or in addition, to make sure that we're having conversations with those individuals so they know what to do. It's very important that you inform those individuals that they have this power and that you've given them this power so that they know it exists, they know where to look for the documents if they need them, and they know how to act so that when you come out of your incapacity, as time goes on, your wishes continue to be followed. Very important. And the last two documents on that chart that I showed you are a last will and testament and a living trust. And the important thing to note in light of COVID is that if you have not reviewed your last will and testament, your trust, or any of your estate planning documents, you should be doing so. Because again, we don't know when there's going to be a time where you can get into an office. Things are starting to open up. We're able to do a lot of things virtually for clients. And you just want to make sure, and I think it's brought to front of mind for everybody, that we want to check in on our plans, make sure our wishes are still being followed, and be in control of what's going to happen to ourselves and our assets, both if we become incapacitated and after death. That's all I have today. I'm happy to take any questions. There's a Q&A box at the bottom, so feel free to write questions in, and I'll wait a minute to see if there's anything in there. And again, like Liz said, I'd love to thank the Westhampton Beach Library for having us today and sponsoring this Zoom and bringing this to you. And we hope to keep providing you information in the future.